Thank you for that wonderful introduction, but I have to tell you, I really am just a very ordinary person, okay? I come from a background of impoverishment, I have to say, and racism. I certainly didn't have life easy, and I often hear people say that they didn't have life easy, but as it so happened, their father had a job, a constant job, reasonably well paid. They didn't have to cut water a mile with their young sister before they'd reached teenage years in a cut-down kerosene tin, which my sister and I carried on a small branch off a tree, and that went on not just for one day, but for year after year after year. They didn't have to find whatever food they could in the bush around them or the seas around them. Not that I think I was underprivileged in that respect. In fact, living off the fat of the land is something we could all benefit from. But no, I wasn't like you when I grew up. Worse than that, when I went to school, I was told I didn't have the brains to keep going in school. Well, when I was in grade 8, and my grade 8 teacher said that to my father as I was about to enter high school, I stood there, gritted my teeth, and said to myself, I'll show you. And that's why I'm here today. All right? And I have to say, it is truly my privilege to have been invited to present this justice talk. Although given the stature of those who've stood here on previous occasions, the Honourable Ron Sackville and the Honourable Keith Mason, I feel more than a little daunted. When I first walked into the law school here, it had moved on from what Ron Sackville described, having moved out of the huts into the library building on the top campus, a very large block of concrete with cold, dark internal stairways, the like of which I had never seen. Having grown up in the bush, right beside the sea, I certainly had a freedom that was completely constricted when I came into law school, probably a comment on the law. In 1973, when I arrived, I was the archetypal bush girl, very naive, pretty much lost amongst those I met here. I was in total awe of lawyers, but people like the founding dean, Hal Wooten, Garth Nettheim, Richard Chisholm, Deirdre O'Connor, Mary Jane Mossman, George Zenkowski, David Brown, and many others made me feel very welcome. Nevertheless, mine was a trepidatious entry into the legal profession. There were other Indigenous students here when I arrived: Paul Coe, Gary Foley, Gary Williams, Bob Blair, and at the time one other male from Western Australia who left shortly after I arrived, and I wasn't responsible for his leaving. Unfortunately, not very much later than that, he died. Those chaps were the first of the fiery, active young men who raised their fists in the salute of black power, which was so familiar to Afro-Americans at the time. They were in the forefront, too, of the land rights movement here in New South Wales. But it would be a mistake for anyone, here or elsewhere, to believe that the movement was initiated in this part of the country. Far from it. The people of the northern parts of the Northern Territory, and even before them, the people of the Kimberleys, had long been campaigning for their rights to their own lands and to other civil and political rights. Hal Wooten himself, as a practising lawyer, had been involved in the campaigns of the pastoral workers in the Northern Territory for equal wages. By the time I and the chaps I've mentioned were studying property law with Ron Sackville at the time, the so-called Gove land rights case had been determined, and we were analysing and critiquing the case, and especially the concepts of native title and terra nullius. Most of my fellow Indigenous students had dropped out by the time I was in second year, Paul Coe, Bob Blair, and I ground on. Well, at least it felt like a grind to me. Those two were engrossed in the... Somewhere I've lost a page. Hold on, let me find it. They were certainly engrossed in the land rights campaigns here in New South Wales. I'm sorry, I've lost a page, because I wanted to go on to talk about the wonderful initiatives of the UNSW Law School at the time, and how so many of the lecturers at the law school at the time became involved in establishing the shopfront legal centres, starting with the Aboriginal Legal Service in Redfern. Redfern, of course, was a very important place for them to start, because it was there that every Friday and Saturday night the police would have their fun with the Indigenous communities that lived in that area. And indeed, there were numerous television programs showing police bashing Aborigines in Redfern yet again. Lecturers from the law school went out to keep watch on those activities. And it was part of that exercise that the Aboriginal Legal Service was first established. And a lot of the students at the time also volunteered to work there. It wasn't long after that, of course, that a number of other shopfront legal centres were established, including those specifically dealing with women's issues with the law, and also youth and their issues with the law. The University of New South Wales certainly made a big difference to the world that we knew at the beginning of the 1970s. My first lecturer here, I have to say, was Ron Sackville himself. And I have a little story to tell about Ron. When we arrived in the lecture room, he asked each of the students to tell why we were doing law. Amongst other things, I stated that I was interested in changing the language of law, as I considered it arcane, bound in traditions which no longer existed, certainly didn't exist here, and which did not reflect the lives of Australians. The prof was a tad scathing at the time. But some years later, when I had been appointed as head of the Ministry of Aboriginal Affairs, and he was the chair or president of the New South Wales Law Reform Commission, our offices were accommodated on the same floor of the Goodsell building, uptown. I would sometimes drop in on him and we would chat about his work. I was impressed by his work at the time because he had become involved in promoting the notion of plain English language in the law, which I thought was a quantum leap on his part. Anyway, now, as you know, in various law courses around the country, including in practical training courses for would-be lawyers, a good deal of emphasis is given to the use of plain English. We've certainly come a long way since 1973. All right, I found this piece that I was looking for. During my short time studying for my LLB here, the school was at the forefront, as I said, of establishing the shopfront legal centre. The concept of the shopfront legal centre spread, as I've already commented, and they've all survived. I'm not aware of any that have closed, but I may be wrong about that. They continue to serve their communities, notwithstanding that governments at all levels have sought to make life extremely difficult for those who work in those centres and for those who need their services. I learned very quickly during my undergraduate days to appreciate the wonderful work in shaping the different law curriculum and community work that this law school initiated under the direction of Hal Wotton and all of those who followed him into the exalted position of Dean. From then until now, I have been a proud alumna of this university and most particularly of this law school. When I was invited to give this presentation, I accepted with alacrity. It is an opportunity I thought I could never have, except perhaps to write an opinion piece for ABC Online. This is a far better time and place to say what I want to say. As no doubt all of you know, and as indeed David mentioned, I have been characterised in the media by police, politicians, and many in the legal profession as controversial. And no doubt some of you will continue to say that of me tonight. Some media have objected that I was a judicial activist, by which they mean that I did not make decisions in the terms of the conservative orthodoxy which prevails not only in society at a general level, witness the recent elections, but also, and necessarily so, as the Honourable Keith Mason observed, by the judiciary. You might recall, those of you who attended, that His Honour stated that all judicial officers take with them onto the bench their values and ideas as to the state of the world. They should take their ethics as well, that is, if they have any. And it's not a throwaway line on my part. The issue of ethics in society, let alone in the legal profession, is a subject of intense interest to me, and it should be a matter of considerable debate amongst all lawyers, let alone other members of the community. However, I'm intending to not be controversial for a change. Not that I set out to be controversial, but however, the greater part of our work in the local court is criminal work. When I first took up my position there, we did very minor criminal cases, masses of quite idiotic parking matters. Once upon a time, you will remember that the Royal Exhibition used to be held at the showgrounds over here in the eastern suburbs, and parking was very limited. So people used to park in Moore Park, on footpaths and so forth. I have to tell you, the very first day I sat in court, I had 1,000 parking matters. I started at 10 o'clock in the morning and I didn't finish until about 7 o'clock at night, after which I went up to the Chief Magistrate's office and said to him, I don't have 2 law degrees and I haven't had the experience I've had in life to do 1,000 parking matters. Nor had I. He thought I was, living out in the outer reaches of the great galaxies. I thought he was living in the past. We had a smattering of civil cases at the same time, but however, within a few years, there were substantial changes in our jurisdiction, and a number of matters that had been the work of the district court were added to our responsibilities, especially with crime, but also with civil work, industrial work, and other areas of the law. These changes occurred as changes were made in legislation, court procedures, and administration. Whereas all criminal prosecutions had hitherto been handled by police officers, and keep in mind it was police officers who laid the charges, who made the arrests, laid the charges, etc. Now, fully qualified and trained lawyers through the Office of the Director of Public Prosecutions handled most of the heavier cases. It remains the fact, even today, that there are still police prosecutors in our local courts. Nowadays, the majority of them are, in fact, properly qualified lawyers as well. One of the great changes, as far as many magistrates were concerned, was that in the manner in which committals were conducted. Since one of the matters which came before me on committal was that of Michael Canaan, charged with attempted murder, of a police officer, I should say, which I dismissed, caused so much comment adverse to me, I wish to make it clear here that a committal is, and always was, an administrative procedure. It is not, nor ever was, a trial. The decision a magistrate is required to make, even today when the committal proceedings, the nature of the committal proceedings have changed, albeit they remain administrative procedures, is two-pronged. Firstly, whether the evidence is sufficient to send an alleged offender to trial, and secondly, whether a reasonable jury, properly instructed, could convict. In cases where the defendant is discharged by the magistrate, the Crown has the opportunity to apply to the Attorney-General for an ex officio indictment to be filed against that person. I want to refer back to something which Ron Sackville said in the course of his presentation of this series of lectures. I personally reject many. In the course of his presentation, he mentioned John Rawls, a philosopher. I have to say, I reject many, if not all, of the propositions put forward by Rawls. Although I once, in fact I think I still do have, at least one of his books, I have put a great deal of my possessions into storage. But going online, one can read, in respect of John Rawls' A Theory of Justice, which was published in 1971. He explains how the logical ordering of principles of justice may answer such questions as how should society be structured, how should basic rights and duties be assigned to individuals, and how should social and economic advantages be distributed to all members of society. Rawls is primarily concerned with defining the principles of justice which would regulate an ideal society, rather than describing how justice may be restored to an unjust society. Rawls argues that the principles of justice which would establish the basis of an ideal society are principles which would be chosen by every individual if every individual were in an original position of equality with regards to rights and duties, and if all individuals were acting rationally in a mutually disinterested manner. This original position is a hypothetical situation in which every individual is acting behind a veil of ignorance as to his or her own social position, class status, individual assets, and personal aptitudes or ability. My point of departure from Rawls and those who subscribe to his philosophies is that justice is a social construct which humans fashioned out of the world they live in at any particular point in time, rather than society being structured in conformity with some logical ordering of principles of justice. The reverse process has occurred through time and place across the millennia. My view is that society is structured by the everyday practices of humans living together. Justice then is devised to serve society. It is not my intention tonight, in fact, to enter into a critique of what Rawls puts forward. I'm much more interested to raise issues of real life. But it follows from what I've just said that nor do I believe there is a standard or orthodox value which we nominate as justice, nor do I accept that there is any universality of common values in society, which is a theme we hear almost by the day, via our media in particular. Sometimes politicians, although I don't know that they talk too much about values, unless they've got a dollar sign in front of them. And I certainly don't think that radio shock jocks talk too much about values. I'm inclined to think that they'd be somewhat puzzled to know what values are. The very wide gap between Indigenous Australians and those of Anglo-Australian background, and just leaving aside people from other ethnic and racial backgrounds who have come to Australia in more recent years than 200 plus years ago, concerning issues of what is right and wrong, of what is just and evil, is evidence enough of the truth of that statement. A few minutes ago, I mentioned judicial activism. Frankly, I don't know the meaning of the term, other than the brief comment I made. But I do know this. Much of our criminal law is now contained in statutes. I'm speaking specifically of New South Wales, which can be readily accessed by all and sundry. I'm sure there are many sundry who wouldn't wish to access our statutes because they can make dry reading. In some parts of the country, it is set out in codes. Here, of course, it is not a code, and we still retain some aspects of common law. The legislation spells out what is a particular criminal act, let's say assault. Nowadays, the term includes battery, as in battered and beaten, as in what happens to women in the home very frequently, and means an unlawful act, either intentional or reckless, which causes another person to apprehend immediate personal violence. I hope not all of you are lawyers, otherwise you're going to be deadly bored. Then the legislation breaks that down into various types of assault, the least being so-called common assault. Then assault occasioning actual bodily harm or grievous bodily harm, assaulting police in the execution of their duty, and let's face it, they are never off duty, are they? Or assaulting a member of the clergy, and on it goes. The same legislation, the Crimes Act, provides for sentencing. It's known as the Crimes Sentencing Procedure Act. While the Crimes Act provides that the sentence for a common assault is a penalty of imprisonment for 2 years, the Crimes Sentencing Procedure Act provides the following. If an act provides that an offender is made liable to imprisonment for a specified term, a court may nevertheless impose a sentence of imprisonment for a lesser term. Clearly, there is a broad discretion there which may be exercised by a judicial officer who is determining the sentence, and indeed the Act specifically states that to be. But those of you who have taken an interest in my career, or more to the point, have taken an interest in what Alan Jones or Ray Hadley or perhaps the Premier have said about me and my judicial activism, might like to know that I was acting perfectly according to law when I handed down sentences that were lesser than 2 years for common assault, or whatever the case may have been. Now, in fact, we can lessen the sentence all the way down to the recording of a conviction without any penalty. A reconnaissance under Section 10, or not, all within the law. Now, if that is what judicial activism is in practice, it's about time all of you held up flags outside of Parliament House and protested about this misrepresentation of just what is available to the citizens of this state, and indeed what is available in terms of sentencing options to the judiciary of this state. The Act also provides aggravating and mitigating factors to be considered in the sentencing exercise. A few years ago, I was, what's this? Almost a decade ago, I'm sorry to say, I was in England. Not the first time I'd visited there, but this was a particularly memorable occasion. After a few days, I'm an avid reader of the newspapers, and I bought every newspaper I could lay my hands on whilst I was there, much to the horror of my friends with whom I was staying, because they thought that reading newspapers was a bad habit. I can understand it to some extent. But one morning, big headlines, in much bolder type than we would ever read here in Australia, the Chief Justice of England and Wales had come out with a statement emphasising the need for rehabilitation over imprisonment. He went on to say, as we often hear in Australia, that's one spelled H-E-A-R and the next one spelled H-E-R-E, that our prisons cost far too much to run and maintain, and there's far too much violence in the community, and so on and so on. Well, we know that. if I didn't mention it, I'll mention it now. Apart from those matters I have already mentioned with respect to sentencing, the Sentencing Procedure Act also sets out a range of factors that we can take into consideration, including aggravating factors and mitigating factors. And they range very widely. I won't read them out, but suffice to say that there is a very broad scope for sentencing. And one of the factors that is involved is whether there are good prospects for rehabilitation of the offender. What is most interesting to me about that is that the provision is not qualified or otherwise restricted by reference to a person's character or criminal record. That is a matter for particular note in the local court. As we all know, especially in the light of the recent case of Thomas Kelly, if we didn't know before, alcohol-fuelled violence is a major issue in society. Unfortunately, the responses, or more appropriately, the reactions to such incidents, is that the offenders should be locked up for lengthy periods of time, if not for life, without any options, and while we're at it, throw away the keys. It no doubt will come as a surprise for most people in the community, and dare say, and for most of you here tonight, that alcohol-fuelled violence has been a feature of this society for about 2 centuries. And for all the time spent in jail by offenders, the problems continue. In the past week, we have heard that New South Wales politicians propose to establish community juries. As Manuel would say, "Ke?" Those less hysterical and not looking to the next poll propose early closing hours for hotels and other liquor outlets. Of course, given that this society is totally wedded to free enterprise capitalism, that is never going to be an attractive proposal, quite aside from the fact of the alcohol industry feeding political parties with big funds. So what can we do otherwise to deal with these types of matters? Before we go on, let's recall what Einstein is said to have stated. Lunacy is doing the same thing over and over again and expecting different results. If we take that proposition seriously for the purpose of this argument, we must surely realise that continuing to send people to jail for offences that have blighted our lives for generations with no improvement in either our individual lives or our collective lives, isn't it about time we stop to reflect on what Einstein said? And just as I'm speaking here tonight, there is a lecture being given at the La Trobe University Centre for Critical Ethics, I think it's called. It was published in ABC Online just yesterday, and the author stated, "We live in a risky, uncertain, grey world, but people crave black and white, good and bad, guilty and innocent, normal and abnormal, healthy and diseased. We have to make decisions about who to imprison or treat. We must recognise that the lines we draw and where we put people are partly and significantly a reflection of our values and ethics." I think the author of that opinion piece is a Professor Salavescu. I'm not familiar with those types of names, and I don't know that I have it I had the pronunciation correct. But I dare say that Professor Salaviscu and I are talking about the same things tonight. Let me just go, I just wanted to put that before you because I'm going to come back to it very shortly. I spoke a moment ago about the Chief Justice of England and Wales proposing that we need to emphasise rehabilitation much more than imprisonment, for example, in dealing with offenders in our society. That was a great turning point for me. That particular visit occurred after the legislation of the Crime Sentencing Procedure Act, which, as I say, contains a provision enabling judicial officers to look at the prospects for rehabilitation. I had not gone down that path previous to my visit to England, although I had frequently thought about it. I was somewhat constrained because we were constantly being told that we should seek to achieve consistency in sentencing. Superior judicial officers were gung-ho on the idea, and the local court administration started to publish sentencing statistics. And at about that time, and I'm now going back into the late 90s, if not a little bit earlier, a lot of politicians were talking about mandatory sentencing. Well, all of you here, or most of you here, know that mandatory sentencing, of course, is a very strong intrusion into judicial discretion. And heaven forbid that we ever should go down that line, although there are some few areas where that has happened. I mean, even within New South Wales, forget about the Northern Territory. Not that it's a lost cause, but I think we need all the revolutionaries we can gather to go up there and do a job. The legal profession, I have to say, with few exceptions, is not the most creative. Straight-line thinking is the norm. Lateral thinking is virtually unheard of. So when I decided that I would move more towards rehabilitation, I had to be very committed to the course I intended to follow. Of course, I read a great deal about aspects of rehabilitation. At the same time as I read all the reports about overcrowding in our jails, the massive costs in keeping jails open, the continuing causes of crime, being impoverishment, generational unemployment, under-education, lack of housing and limited access to education, and of course, the lunacy. As I frequently commented to offenders before me, this is not the easy road. Going to jail is the easy road. You can sit there for the next 5, 10 or 15 plus years and come out no better than you were when you went in. In fact, you are more likely to come out worse than you were. I would warn them that what I intended to do would make them work for their freedom, if I can put it in those terms, for the chance to stay out of jail. I started with drug offenders. The first step was to send them to a psychiatrist or psychologist for an assessment. I required the reports. Then came the Section 11 remand. And in fact, Section 11 of the Sentencing Procedure Act sets out step by step how to go about setting out a rehabilitation program for offenders. Section 11 is the section which enables the judicial officer to defer sentencing an offender, indeed for the very purpose of assessing the offender's capacity and prospects for rehabilitation. I would then structure the bond according to the needs of the person and his family. It was usually a he, although more and more so in recent years we've seen growing numbers of young women before the courts for similar types of offences, which is a change in the way that society has, I was going to use the word developed, but I think that's absolutely the wrong way to describe what's been happening in recent times. And the further purpose was to allow the defendant to demonstrate that rehabilitation had taken place. I would always incorporate into it an intervention program, whether it was by way of psychological counselling or whether it was by way of a residential rehabilitation program for either those affected by drug addictions or alcohol addictions, or for that matter, personality problems, apart from mental illness, which is another, in another field again. The great advantage for society in our taking this approach is that it is much less costly, always a high order issue in the community's books, and much more effective in terms of outcomes. As I said, so many people who go to jail come out and go back to jail, come out and go back to jail. I tell you now, it is not unusual to see pages and pages and pages of criminal records. It is no wonder, it is no matter for wonder that so many of those who appear in courts on criminal charges have lengthy criminal records. We've been practising the lunacy for centuries. So we have to, as I say, think about how we change this state of the world. Violence, I believe, is part of the nature of human animals. However, we are, as humans, we have self-awareness. We are able to control our impulses, and we are able to modify our responses to perceived threats. Indeed, we use precisely those kinds of tools with our animals, with our dogs. We can use them on ourselves. So, what is the cost in taking the rehabilitative path as against taking the path to imprisonment? I'm bold enough to suggest that it would be much less than the horrendous loss of human life at the hands of those just like us. The person who killed Thomas Kelly is not a monster. He is an ordinary, everyday lad in our society. I don't know whether he drank more alcohol on that night than every other ordinary lad in our society does on a Friday night or a Saturday night. But you look at him walking down the street, you wouldn't know him from a young novitiate, let us say, training at Moore College. It would be much less than the needless waste of money used to keep jails open. It would be much less than it costs us in the lack of housing, hospitals, schools, jobs. It would cost much less than the dysfunction and enemy that plagues our communities and our society as a whole. We would start to see the disappearance of that risky, uncertain grey world. We would not see in its place that hypothetical, perfect society that John Rawls imagined. Rather, we would deliver unto ourselves justice for far greater members of society, according them respect as individuals, thereby redefining our values and ethics. It won't be perfect, but it will be much better than we know today. Thank you.